Strangulation charges in Bronx domestic violence cases. Strangulation charges in Bronx domestic violence cases represent some of the most aggressively prosecuted offenses in New York criminal law. New York Penal Law Article 121 creates three separate strangulation offenses, ranging from a Class A misdemeanor to a Class 100 violent felony. Even an accusation can upend your life, housing, and family relationships before any verdict is reached in court. Criminal obstruction of breathing under penal law, Section 121.11, serves as the baseline offense, requiring no physical injury. A person commits this Class A misdemeanor by intentionally impeding another's normal breathing or blood circulation through pressure or blockage. Conviction carries up to 364 days in jail, probation, community service, or a combination of these penalties. Strangulation in the second degree under Section 121.12 elevates the charge to a Class 500 violent felony. Prosecutors must prove the same conduct as the misdemeanor, plus an aggravating result like stupor, loss of consciousness, or physical injury. Physical signs such as red marks on the neck, petechiae, and voice changes often influence the charging decision. This conviction carries a determinate sentence of 2 to 7 years in state prison with mandatory post-release supervision. Strangulation in the first degree under Section 121.13 represents the most severe charge as a Class 100 violent felony. Prosecutors must prove the defendant's conduct caused serious physical injury, a significantly higher threshold than ordinary physical injury. Under New York law, serious physical injury means physical injury creating substantial risk of death or protracted impairment. This conviction carries a determinate sentence of 3.5 to 15 years in state prison. Bronx prosecutors in the DA's Domestic Violence Bureau rely on medical records, SANE examinations, and emergency room documentation. Petechia, or burst blood vessels in the eyes and face, serve as hallmark signs frequently cited in prosecutions. CT scans, photographs taken at different intervals, and witness testimony all strengthen the prosecution's case against defendants. 911 recordings may be offered under hearsay exceptions, even when complainants later recant or refuse to cooperate. The difference between second-degree and first-degree charges often comes down to a single medical finding or imaging result. Former prosecutor David Mejia Colgan has more than 25 years of criminal law experience defending these cases. As a former attorney in the Bronx County District Attorney's Office, he understands how prosecutors investigate and build strangulation cases. The law firm handles cases in both Bronx Criminal Court for misdemeanors and Bronx Supreme Court for felony charges. Defense strategies must address the specific elements. Prosecutors must prove beyond a reasonable doubt for each degree of strangulation. Contact David Mejia Colgan, ESQ, at 784-484-8820, located at 910 Grand Concourse Suite 1F, Bronx, New York 10451, for a confidential case review.